received her law degree from Duke, so her credentials are impeccable. Dean, I turn it over to you.
Thank you, Scott. Good afternoon. This afternoon's panel involves the important topic of whether there can be a meaningful and effective legislative response to the incredulity, anger, and fear that we associate with the events of September 11th. What have we achieved with the USA Patriot Act and other security measures? How do we best prevent future acts of terrorism and balance this prevention with the protection of civil liberties? Just 2 days ago, federal prosecutors charged a New York lawyer with terrorist conspiracy. The charges were brought under a new rule that allows the Bureau of Prisons to monitor conversations between lawyers and inmates who are threats to, quote, commit future acts of violence and terrorism. Have we just witnessed a legislative chilling effect on the attorney-client privilege? I hear some affirmance of that. Well, this afternoon's panel is stacked with lawyers. We do have one reasonable person who will give comments in the middle, but I'll now introduce that panel. Our panelists for this afternoon's session are Professor Christopher Schroeder, Professor Richard Kohn, and Professor Louis Bilionis. Professor Schroeder is Charles S. Murphy Professor of Law, Professor of Public Policy Studies, and Director of the Program in Public Law at Duke University. He has held senior positions in both the executive and legislative branches of government, having served as an Assistant Attorney General in the Office of Legal Counsel of the United States Justice Department, as well as Chief Counsel to the Senate Judiciary Committee. He writes on a broad range of topics, including separation of powers, administrative law, Congress, and risk regulation and theory. Professor Schroeder received his bachelor's degree from Princeton University, his divinity degree from Yale, and his law degree from the University of California, Berkeley. He is married to my dean, who you heard from this morning, Dean Kate Bartlett of the Duke University School of Law. Professor Kohn is a professor of history at the University of North Carolina at Chapel Hill, where he chairs the curriculum in peace, war, and defense. He specializes in American military history and civil military and has taught at the National and Army War Colleges. He recently co-directed a large research project that compared the values, attitudes, opinions, and perspectives of military leaders with the civilian, elite, and general public in the United States today. For 7 years, Professor Kohn headed the Triangle Institute of Security Studies. His consulting for government includes the Hart-Rutland Commission, which reviewed United States national security policy and institutions for the 21st century. Professor Kohn received his bachelor's degree from Harvard University and his master's and PhD degrees from the University of Wisconsin. Professor Bilionis is Samuel Ash Distinguished Professor of Law at the University of North Carolina, Chapel Hill. He serves on the state and national boards of the American Civil Liberties Union, ACLU. He has served as an appellate defender, where he represented indigent defendants in capital punishment and other criminal cases in North Carolina's appellate courts. His research and teaching areas include constitutional law, criminal procedure, and evidence. Professor Bilionis received his bachelor's degree from the University of North Carolina at Chapel Hill and his law degree from Harvard. Professor Schroeder.
Thank you very much, Dean Mills. It's a pleasure to be here, and I thank the organizers for inviting me to participate. The legislation the President signed was an unprecedented restriction on our constitutional rights. No innocent person should object to the measures that have been taken, because the protections of the Fourth and Fifth Amendment only those two statements are obviously contradictory. And neither one of them, of course, applies to the legislation that we are addressing today. The first was uttered by someone after the Congress passed the last Anti-Terrorism Act in 1996. The Anti-Terrorism and Effective Death Penalty Act, as it became to be known upon enactment. And the second was a paraphrase from then Attorney General Meese speaking in the 1980s on an entirely different subject. But I bring them to you just to demonstrate that the question of the balance between civil liberties and national defense that we're discussing today and the country is discussing has actually been teed up in our history for a long time. And in fact, a fair number of us fall out into one or two camps on this debate whenever it comes up. There are those who think that the government has already taken away many of our civil liberties and deprived us of many of our constitutional protections, so that, of course, anything further that Congress does is yet an additional throwing of salt onto the wounds. There are others who think that no technicality of the Constitution ought to stand in the face of the exigent need to protect the peace and security and prosperity of the country, so that, of course, civil liberties need to give way at such times. And then, of course, there are people in the middle who are willing to entertain the possibility of some reasonable restrictions and yet worry about whether the right balance has been struck. The existence of the two opposing camps, though, means that this kind of discussion is always going to be fraught with a lot of hyperbolic rhetoric, salted within which is often some very perceptive analysis, but frequently we have one side calling the other, as Bruce Janice said this morning, soft on terrorism, and the other side calling the other nasty names out of our past. I won't necessarily repeat, but words like McCarthy come to mind in that context. What I want to do this afternoon is three basic things. First, provide you with one kind of framework to think about the issue of the balance between civil liberties and national security. Second is just quickly sketch the main elements of the USA Patriot Act to illustrate one part of that framework. And third, to end with the question of how do you yourselves approach the problem of thinking about where we ought to fall along a number of possible points on a continuum. The framework I want to suggest is actually borrowed from work that the late Aaron Wildolski did in the context of risk regulation and the environment. He offered two idealized models of society. He said, on the one hand, society could be anticipatory with respect to environmental risks. It could check out every action that fell within a broad category of potentially harming the environment and ask for pre-clearances for those activities, permits to be obtained from the government, risk analyses and assessments to be done ahead of time, so that you would front-load ex ante a lot of regulatory requirements to try to make sure that very little that was harmful to the environment slipped through the sieve. And the other, he said, is you could be a resilient society and allow a lot of activity to occur because it's in the nature of things that in the anticipatory mode, we'll ask people to get permits for things that turn out not to be harmful at all, and to that extent we're wasting resources. Let's just let people make judgments about the right kinds of behaviors to engage in. And then once we spot somebody committing a crime or a tort or damaging the environment, we can sanction them heavily, and that will send the right kind of signals to future actors not to behave that way, and we can compensate for the losses. Wildolski definitely preferred the resilient a screed against what he saw as the anticipatory direction that federal regulatory policy was going in general at the time. But you could apply the same model to all kinds of risk regulation, of which terrorism legislation is one variety. And here too you can have an anticipatory kind of posture versus a resilient kind of posture. And in fact, we have historically had agencies that are reasonable exemplars, not perfect because everything's mixed in the real world. There are no ideal types. But historically and traditionally, the FBI has been a very splendid, competent agency in investigating crimes and zeroing in on people once there was a substantial suspicion to believe a crime had been committed or was imminent. The CIA, on the other hand, engages, the NSA engages in lots of anticipatory activity, surveilling widely across the globe all kinds of data gathering techniques through sophisticated methodologies. In fact, inundating our intelligence apparatus with so much data that just a minor amount of it even gets processed. So that one of the responses to 9/11 is to try to beef up our capacity simply to analyze and interpret information that we're already receiving under pre-existing authorities. So those might represent as close as you could come to exemplars of the anticipatory response to terrorism versus the resilient response. And what I want to suggest to you is that the effect of the USA Patriot Act is to move us incrementally closer towards the anticipatory end of that spectrum, to emphasize surveillance, anticipation, prevention, both domestically and internationally. When you look at the title of the statute, the USA Patriot Act, which of course means the statute uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. So what we are after is improving the capacity of our intelligence and law enforcement apparatus to surveil ahead of terrorist attacks occurring and to prevent them from occurring. And that is a certain kind of choice that society can make. It is the kind of choice that will inevitably catch in its net individuals and activities that will, in retrospect, turn out to be innocent, innocuous, non-violative of any criminal statutes, let alone terrorist in their nature, because that's inevitably the way anticipatory surveillance has to work. If you're going to catch the few events that are going to prove dangerous, you've got to throw your net very broadly to gather lots of intelligence information that will inevitably embrace innocent pieces of information and innocent individuals as well. And that is one of the generalizing characteristics that I would use to describe the USA Patriot Act in its content. In fact, I think you could look at the Act as having 5 major components or types of legislative response to the acts of September 11th. I think the most significant for my remarks today are those that add to surveillance authorities. But there are also substantial money laundering and financial institution regulatory measures which are in a separate title of the bill, but which also operate to give the federal authorities greatly increased powers to surveil and monitor and track the kinds of financial transactions that might be a tip-off to terrorist activities. There are immigration and border control provisions. There are explicit intelligence gathering and information sharing provisions. And although it's it's not part of the act, I think it's part of just any fair statement of the legislative responses to 9/11, you'd have to include the victims' compensation legislation that was passed along with the airline stabilization bill that came out of Congress just a week after 9/11, and which the Department of Justice is now developing regulations and an implementing framework to carry out. But just briefly then, surveillance. There are three legal sources of surveillance domestically. Title III, which governs the standard criminal investigations that the FBI might carry out. The Foreign Intelligence Surveillance Act, FISA, which gives the FBI the authority to conduct essentially the same types of surveillance activities, but under a much lesser standard than the probable cause standard that applies to the normal criminal investigation. And this gray, ambiguous, inherent authority of the president to carry out warrantless searches pursuant to his foreign affairs and national security powers and responsibilities. Gray and fuzzy because scholars and courts disagree on the extent of that authority. Of course, the USA Patriot legislation doesn't try to impact directly on the president's inherent authority, but it does make changes in both Title III and FISA, and largely to do two things. To bring the two into harmony so that the authorities or the types of methods and technologies that the law enforcement agencies of the country can use under one are the same as they are under the other. Something that had, the authorities had spread apart over the years as one act was amended but the other wasn't. The USA Patriot Act goes a far way to bringing them back into sync. And secondly, to update the authorities to make them responsive to new technology, primarily the computer and the internet. So you have such ingredients in USA Patriot as the availability of roving wiretaps. So I get a wiretap authorization on an individual and I get to follow him or her around to whatever telephones he uses throughout the country. The national wiretap authority. Sneak and peek searches, where I enter your apartment without your knowing it, take a look around, maybe leave an eavesdropping device, maybe put a chip in your computer, and depart. The law now allows for me to do that under some circumstances where I can demonstrate that a normal procedure of serving a search warrant on somebody is going to have an adverse effect on an investigation, and then I can defer letting you know about my intrusion if that continues to be the case. And I can go back to a judge every 90 days and get that authorization to remain undisclosed to you extended. Of course, that's exactly the kind of surveillance that intelligence gathering often entails, where the ambition is not to try to catch a criminal, but to snoop, get inside someone's clandestine plans and activities in order to prevent what their plan or conspiracy is all about. We've expanded the trap and trace and pen register authorities to the internet, essentially making email the same, putting the email on the same footing as the telephone, but doing so in a way that civil libertarians worry will allow the FBI to in fact capture much more substantive information when they grab your email, ostensibly simply to get the email address from it, than a pen register or a trap and trace technology does on the telephone. Credit card subpoenas, voicemail seizures are now authorized, and a number of other provisions. As I said, the Title III searches, those that are conducted under the normal criminal provisions of the U.S. Code, are those that the government has to meet a probable cause standard to obtain from a judge. The FISA warrants have always been a different standard. There you simply have to demonstrate that you want to surveil the agent of a foreign power. A higher standard if the agent is a citizen, but a very low standard if the agent is a non-citizen. The USA Patriot Act allows now for the government to obtain FISA warrants, intelligence gathering oriented warrants, more easily than they could beforehand. It used to be that the intelligence gathering had to be the purpose of the investigation, and now it can be a significant purpose of the investigation, so that some criminal prosecution intentions can be in the government's mind as it's obtaining the FISA warrant without requiring the agents to be hypocritical about what it is they're asking the secret FISA court to authorize. And the authorities have been extended beyond now simply agents of foreign powers to those who might have relevant information regarding a foreign intelligence investigation. So the scope of the individuals covered by the FISA warrants has been enlarged. As I said, there are a number of follow-the-money kinds of provisions in the USA Patriot Act. A host of authorities that, everything from increased forfeiture powers to greater authority on the part of the government to demand information from financial institutions and to get it faster. Requirements that banks be aware of the nature of the entities they're dealing with overseas and become either prohibited from dealing with them if they're things like shell banks, or have to turn over information immediately to the federal government about the nature of the transactions through rapid reporting requirements. There are a number of changes to the immigration and border control laws that make it that expand the grounds on which the government can exclude people attempting to enter the country and can deport people or detain people who are in the country. There's a broad authority in the Attorney General dealing with people who are called, who are described as terrorists engaging in terrorist activities. And that term of art has now been expanded to apply to non-terrorists who render assistance to a terrorist organization, even though they're rendering assistance to non-terrorist elements of the organization. So the classic example is Hamas sponsoring a hospital for Palestinian refugees and making a contribution to the hospital. Under that broad definition of terrorist engaging in terrorist activities, if I'm a non-citizen, I've just become vulnerable to a possible deportation order by the Attorney General. And there are intelligence gathering provisions, giving among other things, giving the Director of Central Intelligence a role in setting priorities for domestic intelligence surveillance, something that the DCI had been walled off from participating in via legislation that was enacted in the 70s. And in general, and that provision illustrates this, in general, an increased information sharing capacity among the different agencies of government, especially across the FBI-CIA membrane, which has been, as I say, one of the areas in which domestic legislation had erected a wall in several significant ways. The USA Patriot Act sets up authorities that are designed to make it easier to share information across agencies in order to enhance the surveillance and investigatory authority. And I've spoken of the victim compensation provisions, which I think are distinct from these other four, and yet worthy of mentioning simply in the interest of some completeness, but I'm not going to discuss them at this time. So, illustratively, this quick trip through the USA Patriot Act was designed simply to try to defend my proposition that the direction in which we are moving is in the direction of preferring more anticipation, more prevention, more surveillance than was our equilibrium point on September 10th. Now, the question is, how do you evaluate whether these measures are on net advantageous to us, or whether they constitute a deprivation of our expectations of privacy and autonomy that are unjustified responses to the events of 9/11. This, I think, is very difficult, and there's a lot of emotion on both sides of this issue. But part of the problem was illustrated to me by a report that appeared in the local Durham paper the day after the Olympics ended in Utah. And the report was on the security efforts that had been made to maintain the safety of the participants and the guests in the just closed Olympics. And the data was given that $300 million was spent on security to ensure a safe Olympics. And the paper said it was worth every penny. And I read that and I thought, well, how do we know? How do we know whether or not we would have had an Olympics fraught with terrorist attacks or an equally safe one if we had spent, say, 1/10 of that amount, $30 million? Still buy you a lot of security. If the same kind of claim had been made in the other field in which I work, environmental law, that we've just spent $300 million on some environmental problem of unknown magnitude, and the comment had been made, and it was worth every penny of it because no environmental catastrophe had occurred, whoever made that remark in the Environmental Protection Agency would be out of a job the next day. You couldn't defend the proposition that it's okay to spend that amount of money on the basis of no disclosed risk assessment or other kind of analysis of the magnitude of the risk. And yet what we are confronted with in this area is a tremendous lack of knowledge on our part as to what the nature and magnitude of the risk is. It's this problem that led Justice Jackson in dissenting in the Korematsu decision, the decision in which the Supreme Court upheld the World War II internment orders, to write, in the very nature of things, military decisions are not susceptible of intelligent judicial appraisal. They do not pretend to rest on evidence, but are made on information that often would not be admissible and on assumptions that could not be proved. Hence, courts will never have any real alternative to accepting the mere declaration of the authorities that issued the order that it was reasonably necessary from a military viewpoint. Domestically, we face substantially the same problem of not knowing the nature and magnitude of the risk. This is not a balance, in my judgment, that one should comfortably look to the courts to try to figure out for us. For two reasons. There's the Justice Jackson problem. They will not be able to put the weights on the scale. That's essentially a political judgment that has to be made, or in that case, a military judgment. And the other reason is that unlike the conversation this morning, which started off on an international law topic in which Professor Greenwood was able to hold up the actions that the United States and other countries have taken against some international law standards that are not perfectly well defined, but nevertheless have stayed static before and after 9/11. Much of what we're talking about, in fact, is happening in an area in which there is a legislative capacity to act. That is, it's not at all clear to me that very much that's been enacted so far is unconstitutional. Some little pieces of it may be. But it's fundamentally a legislative judgment that's occurring as to where to strike the balance here. And so that in effect, the USA Patriot Act moves us along that continuum, and there's no independent legal point of reference to tell you whether we've gone too far or not, save perhaps in a couple of specifics in the statute. So it's up to the polity to make a decision as to where along that continuum we wish to be. And for that to be done, we have to rely upon the entire apparatus of elected government and the free press, and our willingness to inquire and to read and to be diligent on this issue in order to inform ourselves about the nature of the risk and the consequences of the changes that we have put in place. So this is a question that bothers me at the moment primarily because I don't have anywhere near the sufficient base of information to make a reasonable judgment about the nature of the risk and the relationship of the measures that have been put into statutes as efficacious or inefficacious, efficient or wasteful in responding to that threat. We need to hope that our Congress will come out of its shell, conduct the kinds of inquiries that the separation of powers in our Constitution charged it with. We need to hope that the administration will be a little more forthcoming. It's proven to be like pulling teeth to get information from it on a number of these issues. And we need to be prepared for the fact that these questions are fundamentally questions of political and social judgment. They will not be authoritatively resolved by the courts at any time soon. Thank you very much.
Well, not being a lawyer, I'm not going to subject the USA Patriot Act to an analysis on its own merits by itself. But like Chris, I'm going to try to put it in some context and judge it on a standard that I'm most familiar with and I think might be helpful to you, and that is a standard of the national security of the United States and what kinds of problems we have had in our past in terms of civil liberties in wartime and in terms of the relationship of the individual to the state. When I look at the provisions as interpreted to me of the USA Patriot Act, I am not concerned on the face of it by most of what I read, judging it against an historical standard. It seems to me largely phrased in terms of modifying or marginally bringing up to date certain aspects of criminal procedure and the, as he puts it, the ability to anticipate and modernizing it in a sense to deal with a very different threat that the country feels in the wake of the 9/11 Act than it has traditionally in wartime. For example, changing wiretaps to roving taps seems to me to be somewhat akin to saying, okay, we've got a different way of communicating here and making email like telephone. Maybe you should say, well, email should be like other mail and not like telephones, but I'm not so sure that that distinction is one that I, as an historian, really see threatening. And I would leave that, in fact, to my colleagues in the law, who are more, I think, able to judge the ultimate implications through hypothetical determinations about what could happen. But like them, I am concerned ultimately in where we're moving. That is, what is the hypothetical? But not the hypothetical that's fully abstract, but the hypothetical that's reasonable to anticipate when the next attack comes and the attack after that. Well, let me start with the Constitution. National security has had a kind of schizophrenic history in the United States. On the one hand, there has been the feeling that providing for the common defense is one aspect of it, and ensuring domestic tranquility is a second, and they're not necessarily the same thing. They're in fact disconnected. defense of the United States at home was always the province of the military. Ensuring domestic tranquility was largely the province of the legal system and only the military as a last resort. But it is when those two really overlap that we have had problems, I think, in our history. Up until 1941, we defended the United States on the basis of hemispheric defense. There was not, although we had begun in World War I and afterwards to consider the fact that war making would be done outside of American territory, that is, we would be projecting our military power. But the military was pondering internal security at the same time and had always been kind of involved in it, from Shays's Rebellion and the Whiskey Rebellion through the Indian Wars, the Mormon War in the 1850s, labor strife in the 1870s and afterwards. And in fact, in the 20s, one of the war plans that the Joint Army-Navy Planning Board had was, they were color plans for different countries. War Plan White was to deal with essentially an internal insurrection. But the military's sense of what was going on was always that it would be called upon to keep order only after the legal system had collapsed, and including the National Guard. The regular military would not be involved. So the question becomes, how do you organize and who is in charge of this system of security? And my fear, quite frankly, is that the USA Patriot Act is not where we should be looking for great worries. It is, in fact, towards the possibility of militarizing some aspects of homeland defense. I'm concerned a little bit about how we will coordinate that and how we will deal with it. The military and the Justice Department have not historically operated in such, how do we put it, intimate cooperation. In fact, they've operated quite separately, but I see a trend coming in which they are going to be linked more closely. The threat that we face today, I think, is quite unlike any that we have been forced to confront since the 1920s, when we were concerned with internal threats. While in many respects it's an external threat, the methods itself are indeed, frankly, internal because the threats are internal to the United States, and so our strategies have to include both the internal and the external, and they have to reflect, I think, a different threat to the United States than most of these laws, with the exception of the most recent ones in the 1990s, were designed to deal with. So how do we, in fact, anticipate or prevent these kinds of attacks? Civilian agencies of the national government are the ones that we look to deal with them. The Justice Department, the Customs Service, the INS, the Coast Guard, FEMA. And how are you going to give them authorities and tools to deal with that? And when you give them those tools, how do those tools stack up against the kinds of dangers of abuse that we've kind of experienced in our history? My sense is what the USA Patriot Act has done is not to go very far in terms of changing those tools. But if, as we intend to do, to create a northern command, and very clearly the government is moving in that address that. The real problems we've had with civil liberties in this country have been when the threats have been perceived to be internal, just like we have today. The Alien and Sedition Acts, in the quasi-war with France, I know you say to yourself, go back, that's really ridiculous, it's so far back. But in fact, the kind of criminalization of statements about the government that the Sedition Act wrote into law, in many respects are of the same category of the criminalization that a similar act brought into existence in World War I. And so my sense is that these things are of a piece. The use of the military, the suspension of the writ of habeas corpus, and the use of the military in the Civil War to try civilians, it seems to me, is suggested in the administration's executive order on military tribunals, and I know that's going to be addressed later in the conference. But it's part, to me, of the same historical continuum. Some aspects of the Cold War and the denial of civil liberties, I guess we called that McCarthyism, Karen-Walter Act, some of that seems to me to be relevant here. When the threat has been largely external, as it was in World War II, those kinds of erosions or invasions of civil liberty were less, although the glaring example, it seems to me, of the incarceration of Japanese Americans in World War II is a troubling precedent if one is, and I think the government has been, again, I suppose, betraying my moderate views, the government has been very well disciplined on this sense. If one is to attribute the threat to any particular group by ethnicity or origin or religion, these kinds of things occur. What are we to make of, then, the historical context? My concern is that the last 50 years we've seen a great expansion in civil rights and civil liberties. We have interpreted them, on the one hand, more broadly, and on the other hand, more restrictively. And I think we have much more liberty than we have had in the past. I don't see the USA Patriot Act making large inroads, although I'm more than willing to listen to my colleague, Professor Bilionis, if he can persuade me. Lord knows I'm as suspicious of the government as many, but not most historians, and I'm certainly more than willing to criticize it, even though I've been a part of it. There are parts of the USA Patriot Act that do disturb me, and that's what I would call the squishy definitional aspects of it. The definition of terrorism, which is the ambassador pointed out to us is really a very difficult problem, is broadened in this act. There is a provision that really bothers me about people who harbor terrorists or people whom they should have known to have been possibility of being terrorists. It really bothers me. And I'm not sure what harboring means. I'm sure there are legal definitions, but I suspect they wouldn't satisfy me about innocence of intent. My concern really is, I think, what I see in the administration's predilections and desires on the one hand, and the weaknesses of the Congress on the other. What the administration asked for in the U.S. Patriot Act was considerably more than it got from the Congress. fear Mr. Ashcroft as a zealot, a person who believes that he's right and that he has the correct moral vision, and that he has the authority to act up to and even beyond what's necessary on some kind of abstract principle of the national security. And I must tell you in all frankly, I fear the President on the same grounds. The clarity with which he sees these things does not take into account the complexity and the ambiguity of what we know historically to have been the problems of American security and American war-making. On the other hand, I see the Congress unwilling, for political reasons, to really challenge the administration. And so my fear is not the Patriot Act. It's the precedents that we have faced in this country before when we really feel threatened. And when we really feel threatened internally. And that is when the military is used to try civilians or to keep order, or when intelligence agencies are used to attack radicals or labor organizations or foreigners, when the balance between dealing with citizens and immigrants, which we now seem to have a real fence between, begin to be eroded because we feel so threatened. And I see that as a real possibility. And I kind of close with one of the more chilling anecdotes that I heard of in the wake of the 9/11 attacks, when one of our colleagues who was an expert on Homeland Security was called before a senator who needs to go nameless but who was normally very attuned to civil rights and civil liberties. Our colleague was asked, tell me, what of the fences between domestic and foreign intelligence do we need to tear down immediately in order to be able to deal with this? And then I'm remembering also in conjunction with that, the very famous words that I think are the most relevant here, and my own problems. I don't know how the legal profession deals with whether they have a problem with this, but I think the most relevant, perhaps, legal text to look at is the case in which Justice Holmes talked about clear and present danger. The dangers that the United States has faced historically have sometimes been clear and sometimes been present and sometimes not. But most assuredly, good people, thoughtful people, informed people, and knowledgeable people disagreed on what was clear and what was present. Thank you.
I'd like to thank Judge Everett and Scott SILLIMAN for their kind offer to invite me here today. It's truly a privilege to be among you, and I'm honored to participate with such fine colleagues as these on the panel. I'm a professor of constitutional law, and I take personal and professional interest in the subject matter assigned to our panel today, namely the civil liberties implications of the Patriot Act particularly, but also more generally, I think, the range of domestic governmental responses in the wake of September 11th. But I'm here today because I serve on the board of the directors of the American Civil Liberties Union, an organization whose commitment to these issues and whose central involvement in their day-to-day debate and development I don't think needs much elaboration before this audience. The ACLU was born in a time of national alarm, of which Professor Kohn just spoke. It was in the midst of the Red Scare, immediate wake of the Palmer raids, a massive series of lawless roundups led by the Justice Department, and roundups that targeted political radicals, many of whom were persons of foreign origin. The preservation of civil liberties, especially in times of national crisis, is the ACLU's singular mission. And hence, the ACLU has indeed been in the forefront since September 11th, articulating the case for civil liberties in countless contexts that have arisen as the nation begins its war against terrorism. My job is to share with you how the ACLU is approaching the security challenges that are raised in the wake of September 11th, an approach which the organization hopes might serve as a model for us all. I should say that in representing the ACLU's point of view, I'm not expected to wear my professorial hat, and what follows thus perhaps won't meet the standards of objectivity to which I normally aspire in a moment like this in an audience before you. But on the other hand, my family and friends will tell you it's very hard for me to take off that professorial hat, and thus it's also quite likely that what I have to say may fall short of the standards of strident advocacy that my colleagues at the ACLU might expect. With that much said, let me begin with an anecdote. It wasn't long after the horrible events of September 11th that the ACLU received a letter enclosing a contribution. In itself, not a remarkable moment, but in this case, the donor wasn't a member of the ACLU, nor was he ever a person who had given to the ACLU before. And he'd taken the occasion in this letter to explain his unsolicited action. He said that after absorbing the shock of those horrible events on September 11th, the first thing he did was sit down and write out a contribution to a fund designated for the relief of surviving family members of these tragedies. And the second thing he did was sit down and write a check to the ACLU because he said he was certain that the organization would have its work cut out for it. Now, from time to time, I've wondered what provoked this gentleman to pick up his checkbook. I doubt very much that he was thinking about Justice Robert Jackson's eloquent observations in the days after World War II. I'd like to share with you another quote from Justice Jackson, not from the celebrated Korematsu case, Warren's Korematsu case, but a less famous case called Woods versus Cloyd Miller Company. Justice Jackson noted there that war can give rise to a patriotic fervor that makes moderation unpopular. And because that's so, Jackson reasoned, there's cause to be skeptical about the ability of our governmental institutions to steel themselves against the emotions and passions, and to strike that true, just, conscientious balance between security and liberty that we often speak about so metaphorically. Always, Justice Jackson wrote back in 1948, the government urges hasty decision to forestall some emergency or to serve some purposes, and pleads that paralysis will result if its claims to power are denied or their confirmation delayed. Now, these words, mind you, came not from a perennial critic of government, but from the consummate insider. Justice Jackson was a trusted advisor to FDR, a president never said to have been shy with the use of executive power, and Justice Jackson was also a lawyer who served his nation as both Solicitor General and Attorney General. Now, I doubt that this new contributor to the ACLU also had the words of Thurgood Marshall specifically in mind, but I bet you that what Justice Marshall did say on one occasion would resonate with this gentleman. Writing in the 1980s about a different kind of war from the one which Justice Jackson had in mind back in the 40s, this time the war on drugs, Thurgood Marshall put the idea in characteristically plain-spoken terms. History teaches that grave threats to liberty often come in times of urgency when constitutional rights seem too extravagant to endure. Now, I'd like to think that the author of this letter to the ACLU also thought that his action was a contribution not just to the American Civil Liberties Union, but to his nation's well-being. If he's a typical resident of the United States, I bet he expected the organization would be standing vigilant in the face of the challenges that were sure to come, and that it would give no unwarranted ground. I expect that he was expecting the ACLU to adamantly assert the absolutism and uncompromisability of civil liberties at each and every turn, and I also bet he expected that we'd sue somebody. And yes, there have been a few lawsuits since September 11th, but in fact, not that many. And I suspect it would come as a surprise to the author of this letter and to many of you to learn that the lion's share of the labor, and there has been an enormous amount of work since September 11th, has occurred not in the courts of law, but instead in the courts of politics and in the halls of democracy. Forms that are not commonly associated with the work of civil libertarians. But so it has been since September 11th, and so I believe it is likely to be for a long time to come in this new war of uncertain scope and uncertain end. It might also come as a surprise to you to learn that the notes that are being sounded by civil libertarians as they do this work aren't the strident and shrill tones that are often associated with the card-carrying civil libertarian as he or she is sometimes caricatured. From the outset, civil rights and civil liberties groups across the spectrum have acknowledged since September 11th that both safety and freedom are essential, and that the pursuit of both requires the striking of that difficult balance. The ACLU doesn't quarrel with that proposition. Indeed, it's the premise upon which all its work in the post-September 11th environment has proceeded. The objective is to be safe and to be free. But by what methods and by what means will we best secure both our safety and our freedom? That's the question that has preoccupied the ACLU since the days after September 11th. And in the organization's estimation, it is that question, a question which is really about methods and means, that poses the single greatest security challenge after September 11th. Answer that question properly, and you have a guide that can successfully walk you through the unforeseeable tests that will be seen in our future. Answer it poorly, and our choices may prove to be deeply regrettable. Now, what I'd like to do with the rest of my time is lay out the ACLU's answer to that question. And it's an answer that features two principal points. Each, interestingly, is fundamentally about method. Let me take the 2 points up in turn. The first principal point that animates the ACLU's approach is the necessity for a thoughtful and deliberate, principled and disciplined analysis of any proposed security measure that involves a potential restriction upon liberty. As I see it, this is the ACLU's effort to heed the lessons of history, lessons of the sort to which Justice Jackson and Justice Marshall, in those quotations which I shared with you just a moment ago, alluded. Decision-making in stressful times, history tells us, can all too often be skewed. Skewed by a tendency to erroneously exaggerate the need for and the utility of a proposed restriction on liberty, and also by an equivalent tendency to erroneously discount the threat to liberty that proposed restriction may pose. We believe we need a commitment to a method that will steel ourselves against those tendencies. Now, taking a page loosely from American constitutional law and its methods, the ACLU proposes, more particularly, that you adopt a general two-pronged test to appraise the acceptability of any security measure that involves a potential restriction on liberty. To be acceptable, such a measure should be both necessary and defensible. Now, by necessary, we mean a showing that the restriction actually will increase our security. A proper inquiry likely will explore important subsidiary questions. Is the proposal genuinely designed to battle terrorism? Will it in fact promote security? Will it do so in ways that other existing measures and governmental resources are unable to achieve? If the answers to those questions are yes, then the measure may meet the test of necessity. But if the answers are no, the test will not be met, and the case for a proper balance can be made. By defensible, we mean a showing that the proposed restriction is narrowly tailored to limit its adverse impact on civil liberties. And again, a proper inquiry will explore important subsidiary questions. How significant are the costs to constitutional guarantees of procedural fairness, free speech, privacy, equality, and the like? What alternatives are available to the government? And at what balance of safety and freedom might they yield instead? As the costs to liberty are minimized, the case for defensibility is strengthened. Applying this approach, the ACLU has had no difficulty supporting a number of post-September 11 measures. If I recall correctly, there were some 17 provisions in the U.S. Patriot Act with which the organization had no real quarrel, including, for instance, provisions to strengthen border patrols and to specifically criminalize biological warfare against the United States. The organization favored, if not in its entirety, at least in principal part, the airline security legislation. And indeed, the ACLU has long supported a number of alternative airline security measures, including baggage matching, limitations on the number of carry-on luggage, and the like. Applying this necessary and defensible test has also led the union, however, to find reason for objection, reservation, or concern with respect to a number of proposals that have been advanced since September. Let me give you a handful of examples. This test leads us to conclude that the sneak and peek searches and seizures of which Professor Schroeder spoke a moment ago, as well as the Patriot Act's extension of the less stringent procedures for electronic and internet surveillance afforded by the FISA to a wider range of investigations, are not necessary and defensible. In each instance, we believe that the provisions in practice will diminish privacy protections even in investigations that are of the traditional criminal variety and which do not present the heightened security concerns that would make out a case for necessity. This test also leads us to strongly object to the practice of profiling in the airport security process, a practice of dubious effectiveness that's rife with the potential for discriminatory invasions of privacy. It's why we have opposed provisions in the airline security bill that forbid non-citizens from serving as airport screeners. 80% of the screeners at the San Francisco airport would be excluded under that law. 40% or more of them at LAX. We find that to be unsubstantiated by genuine need and altogether too close to be the product of prejudice. This test leads us to object to the President's court order calling for military tribunals. We're skeptical of the necessity of such tribunals and the significant curtailment of procedural protection they entail in the absence of any serious showing that civilian courts are not adequate to the task of administering justice in such cases. Let me proceed, however, to the second dimension, the second feature of the ACLU's approach to today's challenges. The second principal point that animates the ACLU's approach, like the first, focuses on the method and structure of decision-making. Stated simply, it emphasizes the need to ensure the capacity of our political and institutional safeguards to do their essential work in the reconciliation of safety and freedom. Now, our system is widely hailed as the strongest that history has ever witnessed, at least by most Americans. And in great measure, that's because of its dedication to free speech, open government, the separation of powers, a network of checks and balances, and independent judicial review. These features constitute the system of political and institutional safeguards that are vital to the preservation of American freedom. When they're maintained and nurtured, they operate to enhance the likelihood that a conscientious and just balance of safety and freedom will be achieved. When they're thwarted, when they're permitted to suffer erosion, the blessings of neither liberty nor security should be expected. Now, in times like these, the maintenance and nurturing of this system is essential, and in turn, in our opinion, demands three critical commitments. The first is a commitment to the preservation of conditions conducive to healthy and full political debate. Expressions of doubt, of question, skepticism, of concern, of outright political dissent, these aren't just legitimate features of a free government, they're the staples of a vital democracy. And that is all the more so in times of crisis. Americans recognize that there's a delicate balance between safety and freedom, and that it must be carefully struck after full, open, and informed debate, rather than by governmental fiat. It only hinders the operation of our political and institutional safeguards when government takes unnecessary action that silences skeptical or dissenting views as unpatriotic or un-American, let alone when it suggests, as the Attorney General did in testimony before the Senate, that those who beg to question or to differ aid terrorists, erode national resolve, and give ammunition to America's enemies. Now, many have risen to chasten Mr. Ashcroft on that point, and believe that a just accommodation of America's demands for safety and freedom can and will be achieved if free-spirited debate and tolerance for difference of opinion are secured. The second critical commitment must be to open government and thus to a skeptical posture toward governmental secrecy. Transparency and accountability are essential to democracy generally and essential to any effort to strike a conscientious balance that secures both safety and freedom. Now, this isn't to say that no secrecy is ever justified. I am not here to suggest that troop movements in Afghanistan should be published. But we at the ACLU are deeply disturbed by what we perceive as a tendency on the part of the Bush administration toward excessive secrecy. Our objections in this respect have been raised most forcefully with respect to two different dimensions. The first, the treatment of the hundreds of individuals who have been detained since September 11th. And second, the government's efforts to cloak proceedings before immigration judges in secrecy. We have labored against that secrecy. We have filed FOIA requests. We have lobbied with the government. And we have also sued. And indeed, have obtained some success in New Jersey on that score. Let me proceed, in the interest of time, to the third critical commitment that I think needs to be underscored here. It's a critical commitment to observing the checks and balances that are essential to our system. The strongest objections that the ACLU has registered since post-September 11th, since the September 11th proposals have been brought before us, are really squarely on this ground. Let me illustrate by pointing out four areas of concern. An erosion of checks and balances lies at the core of our opposition to the broader surveillance and search and seizure authority conferred by the Patriot Act. To make the complicated legal story short, the foundational protections of search and seizure law are two requirements. First, that such activity be justified, and second, that the justification and the scope of the activity be the subject of judicial supervision. In important ways, the Patriot Act relaxes both requirements, marginalizing the role of the neutral detached magistrate as a check on governmental surveillance, search, and seizure. Similarly, the ACLU's opposition to the President's order establishing military tribunals is grounded in the belief that it flouts the separation of powers and undermines the role of the judiciary. Such tribunals bypass the civilian criminal justice system altogether. Unlike those that President Roosevelt authorized, these have not been supported by congressional authorization in a declaration of war. And finally, the tribunals, as contemplated by the Defense Department's guidelines, fail to provide judicial review. A concern for the preservation of checks and balances also underlies our concern with other measures, in particular the detention of immigrants. We believe that the Patriot Act's detention provisions in their operation could yield to indefinite detention of certain immigrants who have been held deportable, but who are practically undeportable because they have been designated by the Attorney General as persons who may engage in terrorism activity or activity that endangers national security, thereby making them unwelcome visitors to other nations. I've taken a look at my watch and I realize that time is running. The ACLU staunchly defends the right of free speech, but that right has limits, and I think I have reached those limits. So, do I have a couple of minutes? Let me conclude with a salutary proposal that we have offered that underscores our emphasis on the observance of checks and balances and the significance of effective, activated political and institutional safeguards. The ACLU has called upon Congress to hold quarterly oversight hearings on the implementation of the USA Patriot Act. Doing so, we believe, will help highlight any government excess in the field of terrorism that eventuates in the application of the Act. The organization also has proposed the establishment of an independent commission of national leaders and prominent academics to monitor and analyze the impact of the Patriot Act and other Bush administration actions. We've also urged Congress to insist that any presidential decision to expand the scope or duration of military involvement into a wider war comply with the War Powers Resolution, and that Congress play its designated constitutional role in that regard. I thank you for your time. I thank you for your attention. I thank you for your concern. I thank you for your dedication to the security and safety of this great country, and to your dedication to the privileges of freedom and liberty that make it. Thanks.
We're going to allow for some questions at this time, and please remember that we have a mic. If you have questions, the mic will be brought to you, and please identify yourself and address the question. Yes.
I'm Steve Dykus from Vermont Law School. This has been a wonderful panel. I have a long list of questions for each panel member, but I'd like to just ask two. I'll ask the first one, and then if there's time and patience, I'll follow the second. On December 19th of 2000, Judge Leonard Sand handed down one of more than a dozen opinions that he wrote in the course of the criminal prosecutions of the bombers of the American embassies in Dar es Salaam and Nairobi. This one had to do with the requirement of a judicial warrant for surveillance of a U.S. citizen abroad. In the course of his opinion, Judge Sand, relying on the Foreign Intelligence Surveillance Act by analogy, announced some guidelines for such surveillance. And those included a requirement of not of a judicial warrant, but rather prior approval either by the President or the AG, demonstration of a foreign intelligence purpose, and also that the target was either a foreign power or agent of foreign power. My question for the panel is this. Do you think that in litigation that we're bound to see over the next few years on this subject, that these standards will hold up? Should they, or some standards like them, be codified for searches abroad? And if they are codified, does the President have the authority, and under any theory that you can describe, to ignore them?
They certainly sound like good requirements to me. Will they stand up in litigation? I must say, and I say this not in the kidding way it's usually meant, I think your judgment's as good as mine on this one. Because I know you've studied these questions for a long time. I know, I could say something, I think, about the U.S. litigation strategy, fairly confidently. I think this administration will push very hard on the proposition that certainly if the focus, the target is a foreign agent, or agent of a foreign power, this administration will want to assert that it has inherent executive authority to surveil, to protect national security. The category that the Keith decision said it wasn't reaching when in the 1972 opinion it imposed some limits on intelligence surveillance, but in the context of a case in which the participants were clearly unrelated to a foreign power. There has been litigation that establishes that the Al-Qaeda organization is a foreign power for purposes of the FISA statute. So I'm sure that cases will be litigated on the ground that Al-Qaeda is a foreign power, whatever the limits that might apply domestically are inapplicable in this area. Whether that's the judgment that the court will reach, I think, again, as I said, your judgment's going to be, I think, better than mine on that. But we've seen lots of indications out of the Bush administration that, among other things it's interested in, it's very much interested in reasserting the unilateral prerogatives of the executive. I'm afraid that's the best I can do.
This is beyond my expertise.
I'd like to leave where Chris left in terms of legal prediction. In terms of how a civil attorney may approach it, I'm uncertain what policies the ACLU would reach with respect to that situation. I can suggest more generally that there will likely be some skepticism about the claim of inherent executive authority with respect to surveillance. Certainly, I suspect there will be great skepticism of that claim domestically. Insofar as you were talking about something that, if I understand the situation correctly, is broad and directly targeting a foreign power, one can see that the case of necessity is stronger in principle and likewise for the framework. I don't know whether there's a specific position we would take or have taken on that scenario.
Yes,
Hello, my name is Raman Nadan. I'm a law student at Wake Forest University. And I had a question about the detainees that are being held and the people of interest. And I was wondering if you could talk more about the legal authority for holding those detainees. Is that something that's expressly created in the Patriot Act for this situation, or is this a power that the Attorney General has?
The Attorney General had some pre-existing authority. It was expanded by the USA Patriot Act. The administration originally asked for the authority to detain indefinitely individuals suspected of participating in a terrorist organization or engaging in terrorist acts. This is one of the aspects of the proposal that the Congress did mute. And now I think they can be held without charges for a week. And then charges have to be brought against them. But one of those charges, of course, would be the commencement of a deportation proceeding. And then under the authority of the Act, they can be kept in detention pending the deportation proceeding. He also has authority under the Act to detain people rather than deport them if the Attorney General certifies that there's a national danger associated with their release.
There's another category of detainee, however, which is, and given my remarks earlier about government secrecy, it's going to be difficult for me to speak with great clarity or with anything approaching confirmation about this, but there are evidently individuals who have been held on what are known as material witness warrants. And these, the legal ins and outs of these warrants are debatable and to many obscure. What's especially frustrating in the civil liberties community is not only the existence of the use of these warrants to detain individuals under uncertain legal circumstances, but also the secrecy with which these detentions are shrouded. I have no knowledge of the number of individuals who are being held on those warrants. I think that's information that is sought, not obtained. But it's another group it's another method by which individuals are being held.
I would add just one that occurs to me, kind of reading of the historical record. And this has to do with inherent executive power and warrants. It has to do with detaining people, and that is courts to defer to the executive branch under the provisions of national security, the, well, I'll say it, the fecklessness of the Congress to stand up to the executive branch when they see no support for it in the population, and they see enormous political danger in making arguments that seem to be either arcane or inapplicable to large numbers of people, or to be, on the face of it, seemingly sensible precautions. My colleague and my colleague's dean made the argument that chilled me, that when you start tampering with the rights of immigrants and you begin to behave differently, sooner or later this slops over, depending again on the circumstances and public response to citizens. Well, that's a very abstract argument to make at this point in time, but I as an historian, and again I'm just engaging in what I would call trajectory worries, okay? In certain kinds of instances, I can see all sorts of prohibitions, cautions, common sense just going out the window if things really turn bad. And so my whole sense of what we are doing now is that we are kind of standing on the edge of a cliff. We have no idea how far it is to the other side. We have no idea how deep it is. We cannot give voice or give, how do I put it, way to our fears. We just have to deal with this as it comes. But I think we have to recognize ultimately the enormous power of public opinion, either to prevent or to permit certain kinds of activities.
The law student.
My name is Randall Cook. I'm a student at Duke Law. Professor Bilionis, my question is primarily directed at your comments, but I'd be very interested in the other panelists' comments as well. You described ACLU and your position in terms of critiquing the administration's reliance on military commissions in terms of the following 3 points. And before I'll preface by saying that I would agree that the administration to date has been reluctant or inadequate in articulating the background, the need for military commissions. But I'd like for you to respond to the following justification based upon the 3 criteria you identified. First, in terms of need, the reason to have commissions as opposed to utilizing existing criminal courts is that the criminal acts committed by the personnel that to be tried in these commissions are acts of violations of the law of war and not of the law of criminal law of society. And therefore, trying those types of acts in criminal law would potentially threaten the context or the procedures of that criminal court. Conversely, correspondingly, the reason not to use court-martial is because of international law's recognition over a fairly historically well-defined pedigree of a distinction between unlawful combatants and lawful combatants, and the recognition of the right of nations to use separate tribunals in order to encourage combatants to comply with the laws of war and the Geneva Conventions. In terms of authorization, that the congressional authorization of use of force is de facto the equivalent of a declaration of war because of the repeated use of the war terminology has made essentially the concept an anachronism. In other words, that Congress will never declare war. It hasn't declared it since World War satisfies that constitutional separation of powers concern. And third, in terms of an appeal, that President Roosevelt's commissions also did not provide for such an appeal, and B, that due to the actions and interests of organizations like your own, that there will in fact be petitions for writs of habeas corpus, etc., which will, in accordance with the constitutional scheme, permit the courts to consider the constitutionality of the executive action. Thanks.
Powerful response. I'm not quite sure how to go, which point to address first. Let me try and come up with a more general response. The tribunal, as first blueprinted by the president, was quite broad, and it was and of uncertain scope. We appreciate that it could be narrowed, and in fact, in some respects, has been narrowed thanks to the Department of Defense's work. And therefore, the case for constitutionality may very well have been enhanced. We believe, however, it's a fallacy to think that simply, and I'm not conceding at this point that the Constitution fully satisfies the particular with respect to separation of powers. But the concern that we have is that there's a fallacy of assuming that what may pass the bare minimum of the Constitution is therefore a satisfactory and wise judgment for American men. As written, the tribunal order could reach many situations other than the much more carefully defined situations that you were alluding to, which might have a superior claim for such treatment, which puts a tremendous amount which puts a lot to weigh upon the future and upon the future discretionary actions of the government. And that's the position that we find unsettling in so many respects with respect to post-September 11 incidents, mainly that there's a sense that so long as the minimum has been met, we may put into place something of uncertain scope and assume that it will be applied in ways that will not infringe upon civil liberties in an unnecessary way. But when that day of reckoning comes, reconciling that imbalance is much more difficult.
Could I make even though your question is a legal question and I'm not a lawyer, I just want to tell you what problem I have with the tribunals. I think they are dysfunctional from the standpoint of the prosecution of the war. That is, they smell of hypocrisy, of self-definition, of our deciding to take these people and put them in a different legal category and in a legal category that, at least as originally written, was so far away from American justice, even the way in which we deal with military crimes, as to erode our ability to keep our coalition together and make a good faith attempt to appeal to public opinion in those parts of the world where we would like there to be grown less suicide bombers. At the same time, I think it also dignifies what happened on September 11th and provides, and here I'm really going to stick my neck out, provides perhaps some legal justifications and grounds and political justifications and grounds to our enemies by categorizing them as people behaving in acts of war. I think it would be easier to deal with them and more properly effective for our dealing with them in world opinion to deal with them as, criminals who have engaged in mass murder than it is to make them combatants and to put them system in which the laws of war may apply. And then last of all, I don't, perhaps I'm playing here to the ACLU's standards, doesn't matter. Is it necessary? And as a person very concerned with civil liberties, kind of in this country, I've never thought the American legal system had difficulty putting people on the slammer and for long periods of time, and even executing them when it found it necessary.
Yes.
Ed Clemmer, United Nations Association. Some significant parts of the proposed legislation refer to the gathering of new information and data that should be useful, hopefully, to reduce, find terrorists. We had a talk by a former CIA operative a week or two ago who indicated to us that the CIA now had much more information than they could possibly analyze. Is putting more information overload on the CIA and other organizations really going to reduce terrorism?
Yeah, well, it's a good observation. Our intelligence apparatus didn't lack for information prior to September 11th. It is a matter of being able to recognize what's valuable in it and be able to act on it. I think the proof of the pudding here is going to be in developing our capacities to discriminate among the information that is coming in, and to develop the ability to target. And I think human intelligence is going to be a big part of this. And of all the areas of intelligence that our intelligence community has been spending resources on in the last decade and a half, I think it's fair to say the human intelligence side is atrophied, especially with regard to these state-sponsored but non-state terrorist organizations. They have a structure that's very hard to penetrate in the first place, and we haven't been giving them as high a priority as we should, in preference to the kinds of things that you can do with satellites and electronic surveillance and signal surveillance and the like, which is where we've been getting the information overload. So I think it all depends on how the intelligence community uses the resources. If they use them to enhance their ability to target, where to concentrate, and I think inevitably in that enhance the human intelligence side of the equation, I think will enhance our capabilities. If we don't, then we're just going to, as you say, accumulate additional piles of information that we won't know how to use.
Well, we'll take these last two questions. I think the gentleman from Vermont had reserved some time earlier.
Thank you very much. Steve Dicus from Vermont Law School. One of the panelists this morning noted that in the 2 years preceding September 11th was a blizzard of commission reports about terrorism. One of those, the report of the National Commission on Terrorism, the Bremer Commission report, took a very aggressive stance concerning the use of the military in responding to a terrorist attack, suggesting that we ought to take advantage of the superior training, durable communications, dispersal, equipment of the military services in consequence management. A different report from the Gilmore Commission, which came out shortly after that, took just the opposite view, saying that the last thing we ought to do is get the military involved, at least any more than in a very minor support way in responding to a terrorist attack. And in the report, there was a very, I thought, thinly veiled sense of anxiety that if the military were given a leading role, that it might succumb to the temptation to take charge in a great Is there any way you can think of, any reliable way to avoid the invocation of martial law at some point in the wake of a terrorist attack?
Well, I think it really is highly situational. The posse comitatus law, which we are so fond of citing, was really, in its origins, simply a method by which the Democrats in Congress wanted to get the Army out of the South and make sure that local officials, Republican officials, didn't use the Army for political advantage in elections. The Army has, particularly the Army, but the military has embraced it essentially as a way to avoid pitting itself against the American people and being diverted from its warfighting mission, which in the 1880s it adopted, beginning with the Navy and then the Army, as its primary role in American society. I'm of the belief that it's really inappropriate for the military. I'm, in fact, published something against the creation of Northern Command or a Homeland Defense Command, because I think the military will take over the Homeland Defense function. It will take over the Homeland Defense function because it's larger, has more resources, but most of all is organizationally and bureaucratically designed to plan and to coordinate and to prepare, and it's simply more effective than domestic institutions, civilian government institutions, in its planning function, because it just does that better. Second of all, the response to terrorist attacks, even a large, coordinated, pervasive one, is going to be nonetheless local. It's going to start with the local people, and it's going to extend and play out locally and regionally. And the military is not kind of designed to deal with that or to prepare for that or to coordinate with local institutions, particularly ones like public health organizations, local law enforcement. They're just not experienced. And as they become more experienced, and do begin to do it, those institutions will take on a military caste and a military set of behaviors bureaucratically. I think it's an intrusion of the military into American life that's unnecessary. I think at the same time that if it really hits the fan in this country, you are going to see the military used massively, because the military has the resources, particularly transportation resources, and an inherent ability to reorient its large resources of people, particularly medical personnel, its organizational abilities, and it has the expertise in dealing with most of the weapons we are worried about. Most of that expertise, in fact, resides in the American military establishment. So I'm not really afraid of martial law, because my sense is that martial law will be used in extremis. I think the vision of military commanders wanting to take over and wanting to have legal authority and so forth is a misreading of the military's attitude. Frankly, the military doesn't want this mission. They're going to go after it because they realize that a void is there and they'll be used anywhere, and some of them see money and resources involved in it. But I think the proper answer to this is a Homeland Defense Command, which organizes the government, or a Homeland Defense Cabinet Agency, which organizes the government properly for this, and then prepares to use the military at certain levels of danger or attack under civilian authority. We are so disorganized from a Homeland Defense standpoint. We are so far behind in terms of fixing the institutions involved. We are so bereft of proper coordination
So I think a lot of this would be solved and the military could be used effectively if there was an institution set up powerful enough to use and coordinate with the military, but not succumb to its bureaucratic power.
We're going to take one final question from the lady in the second row.
Judith Steen from Florida International University. During the course of the day, we've heard a certain amount of faith expressed in public opinion and in debate. I would like to know what the panel thinks about the prospects, the possibility that we actually will have a debate, and that we might hear something from Congress and the media. I find it refreshing to be here, but I've heard very little debate. Just thinking back to the Gulf War debates in the two houses, as people decide whether or not we're going to war.
Prospects are low. The closer we get to November, the lower they get. I think we won't have much debate between now and then, unless we have another event. And then the debate will take on a kind of nasty, pointing fingers, who's to blame for this one kind of aspect. But I think that the Congress is in election mode, and the administration doesn't want to talk. And the press is still mostly rallying around the flag. And just predicting now, I'd like to have a debate too, but you just asked me a predictive question, I would say not much.
I agree.
I don't disagree, but I'd like to share something I read the other day. As distance in time comes between decision making and crisis, the capacity for input, for reflection, for more careful analysis. I'm not necessarily suggesting a full board public debate, but a more conscientious, fuller appraisal of all that's going on is naturally more easy to attain. I think it was the Wall Street Journal that reported recently that post-September 11th style measures that are being brought to the floor of state legislatures recently have had a much more tough going. They've been much more scrutinized, and that the surmise is that proposals of the sort that would have had a much greater likelihood of success in September or October are now getting a harder look. Another point to highlight, I think, and this is a personal point of view. One thing that may be regarded as a point of commendation with respect to the military tribunal episode is the fact that time passed between the announcement of the general objective and the filling in of the details, and it did allow for people to stop, pause, provide input, and by all accounts, it had some effect on the decisional process, and has not satisfied civil libertarianism completely, but there's much there that might not have been there had a firmer blueprint been put out in October, for example. I'm not saying that, but you take what you can get.
Please join me in thanking our panelists for their contributions.